Hello there, your immigration lawyer Mustafa Setin here. I hope I'm catching you at a good time. Today's topic is immigration through marriage. So you just got married or you're about to get married and you have a lot of questions naturally, but you're confused because everybody around you who went through this process once keeps telling you one thing or another and they think they're an immigration expert, unfortunately. But fear not, because you are in the right place. Today I'm going to go over the basics of marriage through immigration. So let's start. So what are the requirements? First of all, what we are talking about is the most common scenario, the most common situation, immigration through marriage situation I ran into. This is a spouse sponsoring the another for a green card while the other spouse is here in the US. You're already in the United States, and it matters if you were admitted or paroled on any status or you entered without inspection. There's a difference to it because you only qualify for a green card filing, I-485 filing, when you're admitted or paroled to the country. And your spouse's immigration status is also important because when it's the US citizen, it's the immediate category and you don't have to be in status to be able to file for adjustment of status and get your green card. Because if your spouse is a green card holder, then you have to be in status to qualify for adjustment of status. In other words, a green card. So your spouse is a US citizen, you have admission to the country. And how does the process work then? It is a straightforward, fairly process because it is an affirmative application, what we call an affirmative application before the USCIS. Simply put, it's a bunch of forms. The level is in the details and nothing is straightforward as it seems. So it is a set of forms, yes, correct, but technically a lot is happening with one single filing. First of all, the US citizen spouse is sponsoring the other spouse with an I-130 form. Simultaneously, because green card is immediately available, a green card application is being filed, I-485, and because of the I-485 being filed, you qualify for work authorization. To get the work authorization, you file for an I-765. And to qualify for adjustment of status, you need to show a certain amount of financial requirements. For that, affidavit of support, I-864, is filed. It is one big filing with a lot of forms. What I want you to understand is something very common, something very key to this whole process is that for immigration purposes, the marriage is always scrutinized since 1980, since the Marriage Fraud Act. Whenever someone gets married and the sponsorship application, the green card application is less than 2 years after the marriage happens, there's always scrutiny. And how does the system effectuate this scrutiny is what I want to talk about. First of all, when you're filing, you are looking at the nature of the relationship. And when you file, the application will be decided with an interview. And that interview, depending on where you live, it's going to happen a year or year and a half after your file. So what I advise my clients is to initially prepare basic documents about the authenticity of the marriage. Documents showing that the marriage is real. You put together simple documents to explain how the couple met, what are their circumstances. And then a year and a half later, at the time of the interview, we prepare another package. With that package, we show that continuation, like the natural progress of a couple's relationship when they got married. And by the time of the interview, we show that they're living together and they are, in fact, acting as a couple, married couple who intends to live their life together. So we use the documents to support that. There are no specific set of documents. It's completely based on your circumstances. And you don't need to provide a certain document. It's not true. Oh, you need this. Oh, you need that. Oh, you need a rental agreement. Oh, you need to show insurance. It's not correct because it's all about the circumstances and the officer looking into your situation and deciding. And what you should understand also is very important. Your officer you'll be dealing with don't have a lot of time. Their time is very, very limited. And they can only look into your file very briefly before you get to the interview. And that's why another reason you don't want to put in a lot of documents there. So what we do, we prepare the application, we file it, and then a year and a half later, let's say, we put together a supporting documents package. And then at that point, I prepare my clients. I prepare the couple for the interview. I simulate the interview for them just like an officer would. I ask them questions, and then after that, they go into the interview. If they want, I can accompany them to the interview, but during the interview, we're very passive. We are just there to observe. We can ask for questions for our clients, And then the officers are experts. They are, imagine being an officer doing this for a certain amount of time and interviewing couples, couple after couple, couple after couple, happening on a daily basis. After a while, with the necessary training, they become experts. So they won't look at you. They try to understand the situation, ask you questions without even you realizing. They, by like casual conversation, by asking casual questions, they understand if the nature of the relationship is authentic or not. And at the end of that interview, if everything goes smoothly, no issues arise, usually a green card is issued within a matter of weeks. And after you get your green card, the clock starts to run for the removal of conditions, because if your marriage is, like we said, less than 2 years old, when the sponsorship happens, there is a scrutiny as to the authenticity of the marriage. And another way the system reflects the scrutiny is through issuing a conditional green card. So when the spouse gets their green card, it's a conditional green card. And after 2 years from the date of green card's issuance, the green card holder must file for removal of conditions. And naturally, this is supposed to be happening with the joint filing of the sponsoring spouse, the US citizen. But there are alternatives to that. Let's say everything goes smoothly, this application is filed, and then a condition on your green card is removed. And at the 3-year mark, after the issuance of the green card, you apply for naturalization. This is unlike other methods, unlike other bases for naturalization. If you're married to a US citizen, you apply for naturalization within 3 years of getting your green card. Thank you for listening. Everybody's circumstances are unique. I highly advise for you to reach out to me over the phone so we can make a quick assessment of your situation to see if you qualify. The process is fairly straightforward. Sometimes I very clearly honestly and openly tell my clients, you don't have to hire a lawyer in some circumstances if you want to put in the work, if you want to do it yourself. But what is not optional is for you to have a consultation with an immigration lawyer. Thank you for listening. Hit that like button if you like, and feel free to share this with individuals who might be interested, who might benefit from this video. See you around.